You and your siblings have inherited the family farm. Maybe one of you wants to keep the farm and everyone else lives out of state. Everyone says it'll work out, but 5 years later, someone wants to cash out. And just like that, the farm's on the chopping block. It's more common than you think, and it's called a partition. A single sibling or owner can force the land to be divided and sold, even if everyone else agrees. Today I'm going to talk about how to co-own land the right way, whether you inherit it or bought it together, and how to avoid costly, family-breaking legal battles. Hi, I'm Jason Wagner, Farm Lawyer. I help family farmers pass the farm on to the next generation every single day. Today we're talking about partitions. This comes up in the context of when land is owned together. So co-ownership can happen in a couple different ways. One is you've inherited the land, whether it's from a parent or grandparent. We've given this to our kids in equal shares. We all own it together now. Another is you might have bought property, together with another person. It was a good idea at the time. Oftentimes, these things are good. It's a good opportunity. You can buy more land when you buy it together. Maybe you bought some recreational property or some hunting land together, or a cabin with other people. This partition actions can come up not just in farmland, but in all types of real estate. So either way, you're now tied together on a major asset. A farmland isn't like a mutual fund. It's really easy to divide a dollar because we can go to cents. We can't split up dirt quite so easily. Each piece of ground is unique. Each property is unique. So, it's not like if I've inherited, 200 acres with 5 siblings, I do not own 40 acres. So people sometimes come into my office and hear that. They say, oh, I own 1/5 of 200 acres. That means I own 40 acres. No, you don't. You do not own 40 acres. In that example, you own 1/5 of 200 acres. There's no fence that says, well, here's my 40 acres, here's your 40 acres. Forget about it. It's I own 1/5 of every clump of dirt, of every blade of grass out there, just as my siblings would own 1/5 of every clump of dirt and every blade of grass out there. We don't own anything in our own names. We don't own 40 acres just in our names. It's not like that. That's not what co-ownership is. So co-owning land without any rules would be the same thing as running a business with 4 or 5 other people and no ground rules. You need a plan. Most of the time when you own property together, you own it as tenants in common. As I said, that means you each own an undivided share of the whole. It's not that each of you owns a whole of, it's not that each of you has your own whole. You each have a share. That works just fine until it doesn't. Well, now what happens if somebody wants out? Maybe it's that a person died unexpectedly. Maybe it's that they no longer want to be involved in this investment, or you got forced into it through an inheritance where mom and dad thought this would work out. We're going to leave everything to everyone equally, but it's not working out. There are a few different ways. One is a cooperative partition. Now, this is the one that I like because I'm not a litigation attorney. We don't spend our time in the courthouse, and I don't want you to either. So with a cooperative partition, this is where everybody can agree on a fair division, where we can split it up into specific ownership. Take my 200-acre example again, and if there's 5 owners, as I said, we don't each own 40 acres because that's just not the way it works. But in a perfect world, let's say this is 200 acres that lays flat and it's all rectangular, and we can divide it up, and now we each own our own 40 acres. That'd be great, okay? That's not real life, but that is an example of a cooperative partition. We're all going to agree that we're all going to walk away with our own 40-acre chunk. But you know just as well as I do that everybody's going to want the best land, or if there's a potential building site involved, I want that piece that has a picturesque view on the bluff and has a creek rolling by underneath it. So, not all pieces are created equal. In a cooperative partition, we still need to treat everyone fairly. We typically do that by saying, what are the respective values of these properties, and we want to make sure that each person ends up with a fair value of what they owned before. So if my 1/5 of 200 acres is worth $400,000, one way or another, I should get $400,000 worth of other land. And depending on the type of land, that might be 20 acres of excellent land with a building site, or it might be, 80 acres of really marginal land, because it depends on what the type of property is. In a cooperative partition, you can also have somebody buying me out. So if I said, well, yep, my 1/5 of this 200 acres is worth 400,000, and I want out, and the other 4 owners all say, well, we want to stay together. We like owning land. We'll just buy you out. Well, that's fine. They can now be co-owners on all this together, and I can get out. But again, the important thing is making sure that, you feel that it's fair, that everybody's understanding and entering into this cooperatively. Or we get to the next one, which is a forced partition or partition action. This is where costs can rise. This is where you sometimes see court battles that drag on for years and years. I've seen them cost in the hundreds of thousands and go, multiple years, 5 years plus. It can get ugly. Nobody fights like family. So this is where one co-owner files in court and says, we need to physically divide this land. If it can't be physically divided fairly, the judge is going to order it. That sounds so easy, but it doesn't happen that quickly, and it doesn't happen that easily. So a judge might say, well, this impractical to divide it, so go sell it at auction. Well, if you're the person that wants to own land, of course, you're not going to think that's fair, so it can be appealed. Courts often don't place a ton of value on the sentimental value of land. The reason they prefer a forced sale is it's much easier to divide cash than it is to divide land. And some land can't be divided just because of the way it is. And the important thing to remember is with a forced partition, any one of the owners can start this. Even if everyone else agrees, we want to own this, we want to keep it together, one person is enough to start a partition action. If one person says, I don't want to own this together, the law is not going to force you to own land with somebody you don't want to own land with. So you can trigger this. I've seen this come up in the context of farmland, family cabins. Maybe one person is so far away that it's impractical for them to visit the cabin, or they have an inability to for other reasons. Is it really fair to keep them as owning this cabin and being responsible for the expenses when they get no benefit out of it and probably never will? So, that's an example where a person might want to trigger a partition because they're not able to work with their siblings on getting out of this ownership. So how can we prevent these problems? One of the ways that I really recommend is with a partnership agreement. So we can form a land partnership or LLC and own this property in a more formal structure. And in that structure, we can designate who's responsible for filing taxes, who's responsible for making sure that we get our rent collected, who's responsible for getting our rent contracts in order. We also can put in our buy-sell terms. What happens if somebody wants out? Are we going to have an appraisal? Are we going to have a fixed value? Are we going to pay that on an installment basis? Or is it going to be cashed out all up front? Do we want to own life insurance on each other in case somebody does die and wants to be bought out? The buy-sell agreement gives us that structure. Even more importantly, in the farm context, if we want to use this LLC to maybe make some transfers during life, we can state in there if we want to make sure that the farm operation or the farming heirs have a right to rent that land for a period of time. And this gives us the ability to make some transitions during life, but also make sure that the land is still available for the operation. Even if you don't have a partnership agreement or an LLC, you can still have a buy-sell agreement for land. A co-tenancy agreement. We all own land together. Here are the rules that we're going to follow. This can really help. It's going to set the expectation. People know what's going to happen if they want out. And it can avoid us from going to court, because we don't have to go ask the court, how do we get out of this thing? It's already in the document. We've already agreed to it ahead of time. It's important to talk now. If you don't want to end up as one of those families that spends hundreds of thousands on lawyers and half a decade on fighting this out, think about it. Get this buy-sell agreement in place, a partnership agreement. That can really help a lot. From an estate planning side, if we have land going to multiple heirs, I always lean towards getting us each person having their own parcel if we can do that. It's not always practical, again, for the same reasons we talked about with partition, but it can, again, help us with forcing these people to co-own land together. So look, I know co-owning land isn't easy, but it doesn't have to be that hard. We can make it easier by planning ahead, having a good estate plan, and getting our farm buy-sell agreement in order. If you'd like help, check out farmlawyer.com, subscribe to my channel for more tips.